This is criminal defense attorney Andy Marcantel, and I got 6 more self-defense videos ready to analyze. Welcome to Quick Draw Law. All right, guys, let's start with a really obnoxious incident that happened in Signal Hill, California at a store. All right, you're gonna see a confrontation here between an old guy in a hat and a heavyset middle-aged guy who's standing in front of him there in the gray shirt. All we know about the incident at this point is that apparently a receipt fell out of the old guy's pocket. The middle-aged guy gave it back to him, or tried to give it back to him, and for some reason that started a confrontation between the two of them. And there he goes, slapping his hat off like a schoolyard bully, and now they're squared up in fisticuffs. The onlookers are enjoying it at this point, apparently. He's backing up, and out comes the knife and the firearm. Not so fun now for the occupants of the store. Still pointing the firearm at him and backing up now. The other man still holding the knife. He kicks his hat as he backs up. Okay, well, a lot to work with there. We don't know exactly why this started, but we do know it started as some sort of a stupid, trivial verbal altercation, apparently, between the two over a receipt. And at that point, that's all it was. It was a verbal altercation. Now, we've all probably heard of the mere words doctrine, and that's a rule in every jurisdiction in the United States that words alone never justify a defensive force. And so that's all we had at this point, up until the middle-aged man, kind of like a bully, smacks the old guy's hat off because he doesn't like what he has to say. And the old guy then returns the physical force, and now they are in a fist fight. So what does that mean legally? That means we have ordinary physical force versus ordinary physical force. Remember, there's 2 different levels of force that are recognized in the jurisdictions throughout the United States. There's ordinary physical force, which is a type of force that is likely to result in ordinary physical injury, so not serious physical injury or death. And then we have deadly physical force, which is a type of force that is likely to result in serious physical injury or death. So it's just a fist fight at this point, ordinary versus ordinary. And you can see the old guy backing up. He's clearly intimidated. He's clearly nervous. He understands this middle-aged man is younger than him, bigger than him. And then after backing up a little bit, he then introduces the element of deadly physical force into the confrontation when he draws out that knife. Now we have deadly physical force versus ordinary physical force. The rule here, of course, is that you are never allowed to bring deadly physical force when you are facing mere ordinary physical force. So the charge for that, typically in jurisdictions, is an aggravated assault charge. In this case, it'd be aggravated assault with a deadly weapon. So the question is his defense attorney going to argue that this actually was proportionate force? Remember that there are lots of different factors that go into analyzing whether the force that you are threatened with is a deadly physical force or an ordinary physical force. And even though the middle-aged man didn't possess a weapon at the time, there are some arguments his criminal defense attorney will be able to make here. For example, a criminal defense attorney can argue that there's a disparity in size, a disparity in age, and can even argue that his client, the man with the knife, suffered from certain physical abnormalities such that even an ordinary punch to the face, for example, could result in serious physical injury or death when it's coming from this much bigger, younger man. So I could definitely see an aggravated assault charge with a deadly weapon for the old man here for pulling out that knife when he was in the middle of a fist fight, but there could be some very good defenses if he has a good criminal defense attorney. Now, on the flip side of it, we have the middle-aged, heavy-set man who has pulled out a firearm in response to the man drawing a knife on him. And surely you're thinking at this point, look, he was already threatened with deadly physical force. He can respond in kind with deadly physical force, right? He's out of the woods. Well, not exactly. And the reason is because he made the first physical contact. In other words, he was the first physical aggressor in this confrontation. You remember when he smacked the hat off of the guy's head? That counts as an assault in every jurisdiction in the United States. And there's a rule, usually hidden away in one of the subsections of all the self-defense statutes in the country, which says if you were the initial physical aggressor, in other words, if you placed yourself into a situation where it would be reasonably foreseeable that you would need to exercise self-defense, you don't get to claim self-defense if you are charged with a crime. What does this mean? Well, a prosecutor could also charge the middle-aged man with the firearm with an aggravated assault and claim that he doesn't get to use self-defense because he was that initial aggressor. Not clear if the prosecutors are going to do it in this case, but it is definitely possible for both of these guys to be charged with very, very serious crimes resulting from this incident. The moral of the story here is don't be a hothead and don't be the initial physical aggressor. So even if you're the initial aggressor using ordinary physical force and things escalate from there, it could really cause you some problems down the line if you have to argue self-defense in any context. And whether this middle-aged guy was justified or not to pull out his firearm, he was definitely acting like a bully when he smacked that old man's hat off his head. He shouldn't have done that. Next, we'll head over to Milwaukee, Wisconsin to see an assault that occurred in the kitchen of a restaurant. Now you're going to see a man walk into the kitchen here, two women, punches one in the face. And the woman in black has now drawn a firearm, pointed directly at him. They're arguing. And he then backs up, arguing with her on the way out. All right, let's give that video a little bit of context there. You're looking at the kitchen of a restaurant. There's two women working in there. The woman who got punched in the face is a waitress, and she was just out on the floor dealing with her customers. The guy who walked into the kitchen and punched her in the face is actually a customer at that restaurant, and he was upset that his order was taking a long time. So he told the waitress, just forget it, forget about my order. I know I've already paid for it, but I would like a refund. I need to leave. And she apparently refused to give him a refund and walked into the kitchen. He then pursued her into the kitchen and punched her in the face while she was standing at the grill. This could have been way worse, in fact, because as she later told the police, as she was falling, you can see her hand reach out, and she actually catches herself on the edge of the grill, which prevented her face from falling directly on the hot grill, which clearly would have resulted in some very, very serious physical injuries. That being said, she certainly wasn't unscathed. She was diagnosed with a major concussion when the EMTs showed up and treated her. Luckily, however, she had the best coworker friend in the world who was there to be the hero. That hero's name is Miranda Schaefer. She had been working at the restaurant for a little while, and as it so happens, she wanted to start carrying her firearm on her during her shifts because apparently the clientele in that neighborhood over the course of the months leading up to this incident had become rowdier and rowdier. And actually just the day before the incident, she finally got permission from her boss in order to carry concealed inside of the restaurant. So very fortuitous timing here for Ms. Schaefer to act as a hero. Now this guy's name is Raphael Calhoun. He's a regular there at the restaurant. And though they report that they've waited on him dozens of times, they've never had an incident before. Well, apparently today was his breaking point. He was not happy with the wait that he was having at the restaurant that day, such that it compelled him to walk in and be met with a firearm after assaulting his victim. Now, there's an important lesson here. Remember, we were just talking in the previous video about proportionality. There's that old adage, you can't bring a gun to a fist fight. That's an adage, it's an old saying that's meant to convey a certain principle, a true principle, which is that you must always have proportionate force. When you pull out a firearm, you need to be facing a proportionate threat of serious physical injury or deadly physical force. But the actual adage, you can't bring a gun to a fist fight, is not an accurate adage. There are plenty of times where it is completely legally justified to bring a gun to a fist fight. All that matters is that you need to be facing deadly physical force, the type of force that's likely to lead to serious physical injury or death. Well, we don't need to speculate about whether or not this would qualify as deadly physical force when he struck her in the face while she was standing directly next to the hot grill. In fact, she did suffer a serious physical injury and almost suffered a much, much worse serious physical injury. Remember how I mentioned in the last video, the prosecutor must consider such things as proportionality in terms of size and disparity, the sexes of the people involved, and whether or not people had any sort of medical conditions that could come to bear on how vulnerable they are as victims. And they also had plenty of reason to believe that the assault would continue unless they actually terminated it by displaying deadly physical force. The guy went back there because he wasn't given a refund. They certainly hadn't given him a refund at that point, and he had demonstrated he was willing to trespass into the back of the kitchen in order to assault them for not doing so. This is ample reason to assume that the guy is a continued imminent threat of deadly physical force. This is 100% justified in pointing the firearm at him and getting him to march out. And luckily, it worked. Now, Mr. Calhoun has been arrested and charged with assault, and Ms. Schaefer spoke to a local news organization. As it turns out, this is now her ex-place of employment. This shift was kind of the straw that broke the camel's back after dealing with lots of troublesome clientele. Nothing like this had ever happened before, and she finally, I guess, decided, this ain't worth minimum wage, I'm out of here, and put in her notice. Now, that being said, she's very proud of what she did. She's very happy that she could have helped out her coworker here. And she had a really good message that she shared with local news. She encouraged all women in particular to not be afraid. That was the term she used. Don't be afraid to learn all about firearms, arm yourself, and be competent and trained. This is a wonderful message, so I'm glad that a good moral has come out of this otherwise very unpleasant story. For our next video location, we're going to perhaps the most depressing place in the entire planet, TikTok. We're gonna watch a prank go horribly wrong and the prankster get what's coming to him. Check it out. All right, so the prank here is that he fills a gas can with water, pours it on people's cars to make them think it's gasoline, and then flicks his lighter next to it to make them think that he's lighting it on fire. Super funny, right? And now the prankster's gonna pick the wrong guy. You'll see him run up and pour it on there. And this guy's not putting up with it. He's got a firearm. Not pointing it. He says, it's water, it's water.
Smell it.
Smell it?
It better be water, partner, or you're one dead son of a bitch. You stay out of this.
Yeah, I don't think you want to do that. It's 2020.
I don't want to do that. You almost died, you stupid son of a bitch.
Amen. What a charming response. All right, let's talk about what we just saw. The prank here, once again, is to make the victims think that he's pouring gasoline on their car and trying to light it. What does that equal? Well, that equals a reasonable belief of a deadly physical force. If there's a gasoline explosion that occurs on the hood of your car that could potentially engulf your vehicle in flames or cause your gas tank to explode, that is definitely an imminent risk of deadly physical force, serious physical injury. So anybody watching this guy flicking a lighter next to what they think is gasoline on the hood of their car is in reasonable apprehension of an imminent deadly physical force. Accordingly, you can absolutely use or display deadly physical force in response to that imminent perceived threat. Even if it turns out that it's just water, every jurisdiction in the United States has something called a reasonable mistake of fact belief. That is, if a reasonable person would have believed that it was a deadly physical force that they were imminently facing, that's good enough. You can still act in proportionate self-defense. Additionally, every jurisdiction in this country has something called a general crime prevention statute. Usually what this looks like in the statute book is it says you're allowed to use or display deadly physical force in order to prevent one of the following very serious crimes from occurring. And then it lists some very serious crimes, usually things like homicides and sexual assaults and things of that nature. Well, almost always on that list of very serious crimes that you can use a firearm to prevent is arson. And this would definitely be a vehicular arson. You can definitely argue that it was eminently necessary to display the firearm or even discharge the firearm for all of these different legal justifications. What I'm saying is, it is my legal opinion that this guy could have pulled out a firearm and shot this kid dead if he reasonably believed that he was trying to light his car on fire with gasoline. I would have gladly taken the case if that guy was charged with a crime for shooting the prankster. Not saying I want this prankster to be shot. I just don't want this type of stuff to happen in our society. It's really, really dangerous. This kid has no idea how close he got to actually being shot. And this is a really disturbing trend. We've already seen a few high-profile instances of pranksters getting shot and then the shooter being more or less exonerated, at least partially exonerated. And so what this tells us is this is a disturbing trend, and courts aren't really putting up with it, and juries aren't really putting up with this type of stuff anymore. So just be warned, if you're a prankster and you want to become the next big thing by pranking random people on the street, you should know that if they reasonably believe that you are putting them in danger of an imminent risk of deadly physical force, they could potentially shoot you and be completely legally justified. And in fact, this is exactly the type of apprehension that this prankster was attempting to make in the minds of his victims. He obviously wanted them to believe he was pouring gasoline and trying to light it on fire. So mission accomplished, he created the reasonable belief, and so he very well could have had to deal with it here had this man decided to utilize deadly physical force. The only thing I don't like about the man's conduct is after he walks around and the guy says, hey, it's water, smell it, it's not really gasoline. His response is, it better be water or else you're dead.
It better be water, partner, or you're one dead son of a bitch.
That's not a good line. And the reason is, in this type of a situation, you cannot use deadly physical force to defend mere property. At that point, if he honestly believed that he's pouring gasoline on their car and trying to light it, we're talking about a vandalization, a property crime here. He damaged the hood of his car, maybe the paint or the exterior of the car with the gasoline or something like that. That's not going to be enough to threaten deadly physical force. That being said, a prosecutor would probably say pass on charges there even with that threat. It's just a verbal threat. He's not acting on it. He's not pointing. He puts his gun away in a reasonable amount of time after discovering that this is not actually gasoline and there was no actual deadly risk to him. And so very, very unlikely a prosecutor would ever want to charge this. So in conclusion, just to echo the words of this wise philosopher poet, you almost died, you stupid son of a bitch. Next, we're heading on over to Houston, Texas to watch a pregnant woman pack some heat. All right, so the guy in the pink there is the would-be robber, and the people in the Charger there are actually his accomplices. We'll talk about them in a minute. And if you take a look on the left side of the screen there, you'll see a pregnant woman standing there with her husband. They're all in front of a convenience store. The guy in the pink is pointing the firearm, walking up. She reaches into the purse. The guy in the pink then pistol whips her husband, and bam, she pulls out the firearm from the purse. He falls on the ground, and look at that. His buddies take off, leaving him for dead. Seems like every one of these quick draw law videos, we always got one video where there's a robbery gone wrong and the accomplices just take off. I guess there's no honor among thieves. Now, according to reporting, apparently what happened here is that he attempted to rob the woman before her husband actually came out of the convenience store. He pointed the gun at her and said, give me your purse. And then she just kind of kept walking and said, no, I'm not going to give you my purse. And then she actually yelled into the store and asked her husband to come outside. In a very odd turn of events, they sat there and waited as the husband walked outside. The guy in the pink and his accomplices didn't take off. They kind of sat there, waited to see what happened, and then at that point went up and tried to attack them and rob them. Nobody said that these criminals needed to be smart, but there you go. It's very, very odd behavior from these folks. Now, we know that the people in the Charger are accomplices of the guy in the pink because video that hasn't been released to the public but has been confirmed by law enforcement shows that the accomplices were speaking to the man in the pink. They could be seen flashing firearms at multiple times, and so they were all kind of coordinating together potentially on this robbery. They're still on the loose. The would-be robber, you saw he got shot, he survived, and now he's been charged with very serious crimes. But as of the time of this filming, police are still looking for the accomplices who were present. Now, you don't need me to tell you this, but this is 100% legally justified self-defense shooting. But not only self-defense, there's multiple other factors in play here, such as a defense of a third party. You're allowed to use deadly physical force to defend a third party if their life is in imminent danger. Certainly your husband's life was in imminent danger as he was being attacked by a guy with a gun, but there's also her unborn child, and there's everybody inside of the convenience store. So this woman's truly a hero. I like the fact that she just casually went into her purse, and she was armed, and he didn't know it. So he had his opportunity to back off, but continued to come forward. She used that deadly physical force in exactly the right time. She doesn't have to wait under the law for the bullets to start flying. The fact that he was recklessly waving the gun around at them in the first place, frankly, is all you need. She could have shot him dead right then and there. She didn't. She waited tactically until he came over. She did everything right here, and she's not going to be charged. Now, this relates back to that previous video we were talking about with a general crime prevention statute. Remember how I told you guys that there are a list of very serious crimes in many jurisdictions that you're allowed to use deadly physical force to prevent? Well, armed robbery with a deadly weapon is definitely on almost every single list in every jurisdiction. You're allowed to use deadly physical force if it's imminently necessary to prevent the armed robbery with the deadly weapon. So pick from your self-defense, your defense of a third party, or your general crime prevention statutes. They all come out the same way. She's a hero. Well done, lady. Your kid is gonna think you are one badass mama someday. Heading over to Miami Beach, Florida to see another robbery that was thwarted, this time at a car wash. Now you're gonna see a few masked men walking up behind the car wash employee. They kind of look like they're up to no good. Now the shooting itself is not captured on video, but there are several rounds fired by the car wash employee, and you see one of the men come running in that camera angle. He was shot in the stomach. He survived, but now our car wash employee runs from the scene, is picked up by cops the next day, and is charged with attempted second-degree murder. But then the cops start to investigate, and multiple witnesses tell the cops that they saw the incident and they believe that this was valid self-defense, that these men attacked him, that they were masked, that they were trying to get his money, that they potentially had weapons. And he responded by shooting one of them in the stomach. They ran away, he ran away, and now he's charged. So it should be interesting to see how this case shakes out. So I know you're thinking, Andy, this wasn't even captured on video. Why is it on this series? And I'll tell you why. I picked this video to illustrate a few really important points that you should know. Number one, your self-defense incident will very likely not be captured on camera. In fact, the vast majority of self-defense incidences in our country are not captured on camera, as they have not been for the vast majority of our country's history before there was a camera on every corner and everybody was filming everything. So what does that mean? This case is going to come down to the credibility of the witness statements as well as the forensic evidence. But the fact that there was no video here should illustrate another really important point about how fragile these defenses can be in the absence of any concrete evidence. Imagine, for example, that our defender did not have any coworkers there, and that it was just the three men that walked up and he shot them. Well, then the police are called, they show up and they talk, and all of a sudden we have the testimony of 3 versus 1. And that one is a very biased witness in the case because he's the criminal defendant. So this could have gone totally differently if there were no other witnesses there. Doesn't it make your stomach a little bit sick thinking about one of these masked men sitting in the courtroom in a nice suit? Now he's had a chance to clean up and get presentable, sitting next to the prosecutor at the prosecutor's table as a listed victim in the case, perhaps even asking for criminal restitution against the defender. Well, that could have happened here if there weren't any witnesses. Next thing that I think is important about this story that we should talk about. A lot of people are saying, well, we've looked into his background and he's actually a convicted felon. Therefore, he's not allowed to possess a firearm. And so therefore, he's in the wrong for using the firearm. Well, this is just a misunderstanding of the law. Your status as a legal carrier has nothing to do whatsoever with the legal analysis for self-defense. Once again, you have to believe that you are in imminent risk of a deadly physical force in order to use deadly physical force. That's it. It has nothing to do with your status as a legal firearms carrier, whether that means you're prohibited due to something like a conviction, maybe a felony conviction or a domestic violence conviction, or whether you were legally committed or whether you don't have the proper CCW permit that's required in your given jurisdiction does not matter for a self-defense analysis. Now, this doesn't mean that the prosecutor's not going to charge you with a bonus crime in this case. And certainly, he's going to be charged with that bonus crime of misconduct involving weapons for being a prohibited possessor at the time of this incident. But it has nothing to do whatsoever in whether he acted in valid self-defense. Now, I should note, it has everything to do with your coverage if you're represented by the vast majority of self-defense insurance companies in this industry. It is not a problem for attorneys on retainer. We don't care what your status is and whether or not you could legally possess the firearm. Perhaps you were a convicted felon, perhaps you were in a sensitive area, perhaps your CCW permit has expired. We don't care. All we care is that you attempted in good faith to act in self-defense. We definitely would have represented this guy. And another really important thing about this issue, this is likely to change. In fact, right now in our courts, we are seeing a national sea change when it comes to analyzing what types of things we can actually deprive somebody of their Second Amendment rights for. You should take a look at the Range versus Attorney General case that happened in the Third Circuit. There are lots of similar cases that are working their way up through the appellate courts, heading up to the United States Supreme Court. In these types of cases, the arguments are being made that, look, if it's a nonviolent offense here, in the Range case, for example, the guy was convicted of food stamp fraud, a totally nonviolent offense that happens to be a felony. And the court in that case said, you can't deprive somebody of their firearms rights if they're not an imminent risk to anybody simply because they have a felony. That's just not the historical purpose of depriving somebody of their Second Amendment rights. So I don't know what this guy's felony is. Maybe it was a violent felony. Once again, it would have no bearing whatsoever on the self-defense analysis. But say it was a non-violent felony that didn't indicate that he was a danger to anybody at all. Well, I'm not even so sure, and the courts might not be so sure, that he should even be a prohibited possessor in the first place. So just a little food for thought for you to chew on when you're analyzing how this guy should and shouldn't have acted. In other words, just because he's been convicted of something that at some point the government said his conduct was illegal, whether true or not, does not deprive him as a citizen of this country of his right to defend himself. And the last big important reason that I chose this case is to illustrate the point of why you shouldn't flee the scene after a self-defense incident. Now, let me qualify that before I get too deep into it. If by flee the scene you mean make yourself safe because there's an ongoing emergency, then disregard everything I'm about to say. If there's an active threat still there on the scene and you act in self-defense, you and your loved ones and anybody else should get out of harm's way. But in a case like this, where the threat was neutralized and the police are on the way and you know that they're on the way and the incident is over, now at this point you should remain on the scene. There's a legally relevant reason you should do that, and that is called consciousness of guilt evidence. What do I mean by that? Well, if you leave the scene and you flee, or you do something after an incident that would indicate to a reasonable person that you believed that you were guilty, the prosecutor is actually allowed to talk about that to the jury and ask them to draw an inference against you that your conduct following the incident reflected a consciousness of your guilt. So when you leave the scene afterwards, you're going to give the prosecutor one more thing to talk about. They'll say things like, well, if you knew you were in the right and you knew you acted in valid self-defense, why'd you flee and hide from the cops? Why'd you make us issue an arrest warrant and drag you kicking and screaming into court? Ideally, after a shooting like this, you have somebody else call 911 and say as little as possible, there's been a shooting, here's the location, send help. If you have to make the call yourself, say as little as possible. Don't even admit to being the shooter. My suggestion is to say, there's been a shooting, here's the location, click. When the cops show up, do not have your firearm on you. Make sure you look like you are surrendering and not an active threat, because keep in mind, they've just been told by dispatch that there's an active shooter or a shooting just occurred at that area, so do not appear to be a threat to them when they show up, and do not make any statements. You should call your criminal defense attorney immediately after a shooting, especially if there's not human life in imminent danger, and especially if you can get a third party to call 911. Get on the phone with us, talk to us immediately, and we will tell you, if anything, what to say. It's really important to have an attorney-client relationship in that moment when you need it the most. So, was this a good shoot? It depends. How is the evidence going to come out? We don't have it on video. How credible are the witnesses? Are there any forensics that can be analyzed? Will the prosecutor make an argument that this was disproportionate force? Or will the defense attorney be able to convince the jury that it was a 3v1 type of a case, that even though they weren't armed, they either appeared to be armed or they presented such a risk by surrounding him or ganging up on him that the use of deadly physical force was justified? There's all kinds of great issues that can be played with here, but first, we need more of the facts. So we're going to be staying tuned for that, and if this story develops more, I'm going to talk about it again on a future Quick Draw. And finally, you know on this show we like to save the funniest video for last. Let's head over to Russia to watch a robber get a big taste of reality. All right, so here's the shopkeeper. This video is taken from behind the counter. You can see a gentleman just walked in. That gentleman is our would-be robber. Now, the shopkeep is clearly on edge here, sees the guy's up to no good, and here comes the criminal with a hammer. And bam, shopkeeper through the door, a couple nice jets of pepper spray to the face, and this guy is clearly affected by it. You can barely see, he's bumping into the counter, stumbling around, feeling around for the drawer with the money in it. You can't see too well, but he's gonna attempt to open it, and he's got his hammer held high, and here comes the shopkeep. Second round. Kicks, punches a few times, and here comes my favorite character, the Good Samaritan. Notice this fella introduces a new element here, the element of the chair smackdown. And as you can see, the age-old battle of the hammer versus the chair comes out with the chair on top. They come out, they check his pockets, make sure he's not carrying, and give him a couple of punches to get him down to the ground, just for good measure. Still working on subduing the guy. He eventually goes down, stops resisting. And a little knee or two, just for good measure. Now, my favorite comment that I've seen on this video is that the reason that this robber was trying to rob this store is he was trying to get enough money to buy a gun so that perhaps his next robbing venture would be a little more successful. But even though he didn't present with a firearm, he definitely was an imminent threat of deadly physical force when he was wielding that hammer. Any jurisdiction in the United States, for example, is going to consider that a deadly weapon and is going to say that the shopkeeper can use reasonable and proportionate force. I thought the use of the pepper spray here was very effective, and at that point, after he was a bit debilitated, he went out and he restrained him. So if this had taken place in the United States, that shopkeeper, in addition to being able to use the force, is actually going to get some additional privileges. In every jurisdiction in the United States, we allow shopkeepers certain privileges when dealing with would-be robbers. For example, not only can they use force to detain them, they can actually imprison the robber for a certain reasonable period of time while they are awaiting for law enforcement to arrive. So for example, if you needed to lock up a would-be robber in a storeroom or something like that while the officers were on their way, you actually are going to have the legal right to do that in the United States. So there are some arguments here that after the guy was on the ground, perhaps they used more force than was reasonably necessary. But hey, it's Russia. They're going to be fine. And frankly, in most jurisdictions in the United States too, these guys are going to be heroes rather than the villains. And that's it. Thanks for tuning in to Quick Draw Law today. And if there's a video you guys want to see analyzed, make sure to leave it down below in the comments, and perhaps we will analyze it for you on a future episode of Quick Draw Law. And while you're down there, make sure to like the video, subscribe to the channel, share it with a friend if you liked it. Go and check out attorneysonretainer.us to learn all about our self-defense program and what it can do for you. And also go check out attorneysforfreedom.com to learn all about our law firm and how we defend people in the criminal justice system. Until next time, this has been Attorney Andy Marcantel signing out. Peace.